Okay, hi again, Attorney Steve Vondran. We are back and we are talking in this episode about how to survive Autodesk audits. Okay, Attorney Steve Vondran, intellectual property lawyer. We take intellectual property cases, copyright and trademark from around the United States. So if your company is located in New York or Florida, Washington, Ohio, anywhere in between, give us a call. We can help you get through these Autodesk audits that are basically threatening copyright infringement against your organization. Okay, so we've handled a lot of Autodesk audits. The main company that you're going to see is Donahue Fitzgerald. That is the intellectual property law firm located in the Bay Area. We have an office up in San Francisco, and they handle most of the Autodesk audit cases. When you get a letter, if you're an engineer, architect, or designer, and you get the letter from Donahue Fitzgerald, you know it's legit. This is a firm that handles most of their cases. Now, also, sometimes you will be subject to an audit through the Business Software Alliance, of which Autodesk is also a member. And so sometimes the audit will be coming through what we call the BSA, or the Software Alliance. Okay, so just something to be aware of. So it could be coming from any of the two entities, but usually that's where you're going to see them come from. Okay, as you see down here, my name is Steve Vondran, attorney. And let's move on to the next slide. By the way, before I go, softwareaudits.net, if you're caught up in an audit, this is a comprehensive resource website that I have put together. I believe that it's the best you're going to find out there. We have videos, we have podcasts, we have helpful articles, we have a ton of different blogs that we've written. So check that out. There's a ton of resources if this video doesn't cover everything you're looking for. Okay, step one, when you get the letter, a lot of people freak out. Sometimes they're threatening $150,000 per willful infringement. So these are things that you need to be very aware of. And again, we will get your cases settled much, much less than that. Like I said, that's sort of a benchmark for willful copyright infringement. But at any rate, when you get the letter, relax. Don't run around and start talking to everyone. Don't start calling in your IT team and blabbing about everything, getting upset, threatening to fire people. You gotta relax when you get that letter. Okay, that's the first and most important thing. Okay, step two, very simple. Lawyer up. Now, some people will say, "Well, doesn't lawyering up mean I'm guilty?" No, it does not mean you're guilty. What it means is you're taking the situation serious, that you want to make sure your legal rights are protected. You want to make sure you're able to explore potential defenses or potential mitigating factors to try to get your damages down. And essentially that you want a firm to handle your case. There's going to be typically a confidentiality agreement up front, what we call the FRE 408. That's a Federal Rules of Evidence 408. So you're going to have that contract up front. You're also going to have negotiation. You're also going to have a settlement. The settlement agreement is going to have various terms that sometimes are negotiable, sometimes are not negotiable, but usually they are. And so it's your way of saying, let's take it off our plate so we can continue to do our business, and let's let Attorney Steve handle this case for us, okay? And so no, it does not mean you're guilty. It means that you want someone to handle this and get it done for you. Don't forget, the people that I deal with, these regional law firms from companies like the Autodesk and the Business Software Alliance, they're people that I deal with are attorneys. They're all copyright lawyers, okay, intellectual property attorneys. So they have lawyers. You might as well have a lawyer. We offer a low flat rate, predictable legal fee for non-litigation cases, which most of them are. So we help you to get the representation so that you can deal with their attorneys. We can haggle while you're running your business, okay? So it's pretty much that simple. And again, step three, we're talking about the FRE 408 Confidentiality Agreement. This is really important to get a good agreement in place so that your discussions, your exchanges of documents are protected. So in other words, if you're trying to get your case settled and you feel it's a disputed claim, you need to get that agreement in place with Autodesk, and we can help do that. But as I point out here on the slide, you never want to admit to willful copyright infringement without FRE 408 protections in place. In other words, you got to be careful. You don't want to, some clients go, well, I'm just going to pick up the phone and call the attorney that's on my letter. And I say, well, you could do that, and we're not going to stop you, but just be careful, because if you're admitting, yeah, We don't have licenses for that. 2 AutoCADs and 2 Revits, 2 Mayas. We don't have the things for it. Why don't you have those? Well, I don't know, it was an oversight. We just don't have them. Sounds like willful copyright infringement. And don't be surprised then if their attorneys would come back and write you an email saying thank you for confirming that you have unlicensed infringing copies of your software. Well, now you're already in a hole. So you've already dug yourself in a hole, okay? So you need to make sure that you're getting a confidentiality agreement in place. We can help you do that. Step 4, I've got my softwareaudits.net link up there for you once again. Step 4, this is sort of the getting engaged process. What do you have? What's your potential exposure? What do they know? Is this an informant case? A lot of times people will ask me, how does Autodesk find out about this software? And there are multiple ways. Sometimes you're buying things on the internet like eBay or Craigslist. You're buying cheap software. I do believe that those are monitored, and that if you're buying software from unauthorized resellers, you can face problems. We've had those cases. Surely, we've had the cases with the informants, what we know as someone who's either a current corporate insider or somebody on the outside that may have found out that you're using illegal software. Could be a competitor that's just making a claim that they believe you have that. It could be that you just posted a new job saying we're looking for someone with AutoCAD experience, and they look your company up and they say, well, this company doesn't have any AutoCAD. Why are they looking for an AutoCAD person? They must be using AutoCAD. Those can trigger letters. Sometimes it's trade publications. We've seen Architect Digests touting off a big project that was created using Revit, and they look the person up or the company and they say, we don't see any Revit installations here, so send them a letter. So those are the different kinds of typical ways. Maybe you downloaded something through a torrent website and were using crack codes to access and use the software. It's another way. So there's lots of different ways they find out, but part of our job is to figure that out. Push some buttons, see if we can figure out what's going on, match that up with what you believe is going on in your organization, and come up with an audit defense strategy. Okay, and that can include auditing, getting proofs of purchases, and usually what they're looking for is dated proof of purchases so they can tell you actually purchase the software. And again, discussing the issues with opposing counsel, evaluating exposure, so forth and so on. So that's kind of some of the meat and potatoes. Once retained, that we go through some of these things. Step 5, obviously the art of negotiation. The thing with Autodesk is we have settled many cases with them. We've worked with all their attorneys. We've been involved in litigation with Autodesk in federal court up in Northern District of California. So we know them, they know me. They know how our firm works. We're tough, but we're fair. And, we want to get good deals for our clients based on where we believe they're at in the licensing process. So that all deals with relationships and the fine art of negotiation. And like I said, if you don't do this on a daily basis, you're an architect or an engineer working on other things, or a designer, let us handle this. We can handle this for you. Hopefully it's one of the few legal issues that pops up in your legal career. So it'll be a small cost of business to try to get your case settled. Okay, step 5. Finally, step 6, and I put up there's the firm, Donahue Fitzgerald LLP. That will be who the letter would be addressed from. Step 6, obviously negotiating the best terms of settlement. And as I mentioned, when you get down to the settlement process, you're going to see a lot of different terms. You're going to see a beefy contract and a release agreement. You want to make sure you're getting the best terms, the lowest amount, confidentiality. Sometimes that can be a sticking point because sometimes they do feel there's some deterrent value in being able to post press releases. So, you got to be careful about that. Again, future audits clauses. Sometimes they want to come back for 2 or 3 years and conduct audits. That's not fun. Officer certifications. As we know in these cases, sometimes officers and directors can be held personally liable. So that's another thing to be aware of, another thing we can discuss with you. Software code of ethics is another requirement. Sometimes they want you to certify that all new employees will see and sign a software code of ethics. That can create some issues. Sometimes we try to negotiate that. And there's other clauses. So at any rate, it's important, like I said, once you get through this process, to get yourself a good solid agreement. Then usually as part of the settlement, you're going to get software. Not in all cases. It doesn't apply in all cases. Some people don't need software. Some people use contractors to do most of their project work. So at any rate, we get you done, we get you settled. If it's getting software, we're negotiating software as part of the deal, and so forth and so on. So that's really kind of the basic nuts and bolts of an Autodesk audit. Here's a list of some other audits we handle. Basically, any type of software company that may be auditing you, whether it's Adobe, Microsoft, Siemens, product life cycle management. I think I spelled Siemens wrong there. Vero Software, CNC Mastercam, SIIA, Software Information and Industry Association audits. They do audits on things as well. And finally, the Business Software Alliance, the BSA, which handles a lot of audits. And that's usually dealing with Microsoft Office products and Windows, SQL servers, Cal licensing, and other things. But if you need help, sorry about that, should probably take a sip of water. So if you need help with an audit, you are received what we call the love letter, give us a call. We're happy to discuss. You can find us for a free consultation, no cost consultation to business owners who have received the letter. And our number there is 877-276-5084. Once again, our firm is the law offices of Stephen C. Vondran, PC. And you can find out more information at softwareaudits.net. That's our treasure trove of resources. We hope this has been helpful. If you need help, we've helped lots of companies and lots of different types of software audits, copyright infringement matters, BitTorrent cases. Give us a call. We're happy to help. And like I said, we try to make this a no-brainer for your organization so you can afford legal counsel in these sticky situations. Okay, have a great day. Hope this helps. We'll talk again.